Thank you, Acting Speaker. I rise today to contribute to the Victorian Civil and Administrative Tribunal and Other Acts Amendment, Federal Jurisdiction and Other Matters Bill 2021. And I'm pleased that the opposition is not opposing this bill. And I've certainly had my experience with VCAT as a member here and in my previous role as Secretary of the Ambulance Union. This piece of legislation is an important administrative work for Victoria. Like many of my colleagues, my office during COVID-19 restrictions dealt with many constituents who were or are currently struggling with tenancy matters during an already incredibly stressful time. Often these issues would be tenancy disputes where landlords in these matters could be located in other jurisdictions outside of Victoria. There, of course, could be many reasons for this. It could be that they have moved interstate or overseas or had purchased an investment from their respective jurisdiction. In this instance, if one of the parties was based outside of Victoria, VCAT, which usually deals with these issues, couldn't address these concerns due to provisions concerning the Commonwealth Constitution. Acting Speaker, this bill makes critical changes so that Victoria's court systems can ensure all Victorians have the appropriate access to a fair justice system. The Andrews Labor government has made sure that our legal system better reflects the needs of Victorians. Successive Labor Party Attorney-Generals have made necessary changes in our system to resolve issues more fairly and more efficiently for Victorians, whilst reflecting community expectations. This bill seeks to address disputes that, for the constitutional reasons, can't be heard by the Victorian Civil and Administrative Tribunal. And it has occurred due to the High Court and the Victorian Court of Appeal making a recent decision that the VCAT Tribunal is not a court of the state under the Commonwealth Constitution. And because of this, VCAT doesn't have the jurisdiction, also known as federal jurisdiction, which matters arising under Commonwealth Constitution. This in particular is of course an issue when disputes arise under a Commonwealth law and residents are in different states or territories. This means that currently, as the legislation stands, any issues or matters with this federal jurisdiction are being turned away from VCAT. This has consequences, especially, as I mentioned previously, for people who are seeking justice in regard to residential tenancies. And if, for example, a landlord is based in another jurisdiction. The Real Estate Institute of Victoria made some comments in March last year, and I quote, "Victoria is a strong real estate market that has attracted investors from across the globe. Having interstate owners of Victorian rental properties is extremely common. This new interpretation will create mayhem for border towns like Wodonga, Echuca and Mildura, and you could own a property a couple of hundred metres away and still not be covered by VCAT. As our legislation in Victoria currently stands in this example, if the landlord is based in another jurisdiction, the matters can't be heard at VCAT. However, if a residency tribunal issues arises with the exact same circumstances but was between two Victorians, then it could be heard at VCAT. This is, of course, an unintended consequence, and this legislation seeks to address this issue by conferring new jurisdiction on the Magistrates Court to help resolve federal jurisdiction matters which can't be currently resolved at VCAT. As I mentioned, the Victorian Civil and Administrative Tribunal has been deemed unable to resolve these federal jurisdiction matters after a recent High Court and Court of Appeal decision decided that because of provisions in the Commonwealth Constitution, only a court of state can determine cases and that VCAT is not that court of state. The High Court held that only these courts of state can determine the particular types of disputes which are set out in sections 75 and 76 of the Constitution, and they include disputes between residents of different states, disputes between a state and a resident of another state, disputes in which the Commonwealth or a person suing or being sued on behalf of the Commonwealth is a party. This has resulted that state tribunals cannot exercise federal judicial power or determine these disputes unless they are able to be described as a court of the state. With disputes that are only presently able to be heard by the Victorian Civil Administrative Tribunal happen to involve federal jurisdiction, it means that these disputes can't be heard and the parties in these cases have nowhere to go to seek justice. It is simply not acceptable that decisions about returning people's bonds or ending a lease can't be heard due to an administrative decision. Renters can be some of the more vulnerable people, especially so during a global pandemic. loopholes for landlords residing outside of Victoria that can put renters in a vulnerable situation simply must be resolved. Some may ask, why can't VCAT be made a court of the state? And converting VCAT into a court of the state would compromise its ability to remain efficient, accessible and a low-cost dispute resolution forum. VCAT has many unique features resulting from it being a tribunal and not a court, and these features allow greater flexibility than a court. These would need to be significantly changed to convert VCAT into a court. And for example, consideration would need to be given to amending the terms of appointment of members other than the President and Vice Presidents to provide greater security of tenure, the number of non-legal members and part-time and sessional members, the composition of the tribunal when it hears matters, and the process for removing members. Other jurisdictions have also had to deal with this issue. The High Court's decision has affected South Australia and New South Wales. Like VCAT, the South Australian Civil and Administrative Tribunal and the New South Wales Civil and Administrative Tribunal cannot resolve federal jurisdiction matters because they are not considered courts. Those jurisdictions have introduced reforms to allow their courts to hear federal jurisdiction matters that cannot be heard by their tribunals. So the SA and New South Wales reforms were carefully considered when developing their bill. Like SA and New South Wales, the bill will allow the Magistrates Court of Victoria to exercise all the jurisdiction, functions and powers that VCAT would have had if it had heard the matters. The government consulted widely with a broad range of stakeholders, and they included the Supreme Court of Victoria, the County Court of Victoria, the Law Institute of Victoria, the Victorian Bar, Victoria Legal Aid, the Office of Public Advocate, State Trustees, the Victorian Legal Services Board and Commissioner, the Real Estate Institute of Victoria, Tenants Victoria and Consumer Affairs Victoria. Acting Speaker, this bill seeks to change that by allowing a person that can't have their dispute heard by VCAT will be able to go to the Magistrates Court to have their case decided. It also imposes the same fee as VCAT to the Magistrates Court and ensures that a party isn't required to pay a fee twice. And this is important for my constituents and I'm sure for all people that access this process. The nature of the Magistrates Court is that it is the more informal of our courts, and judicial officers and staff have experience dealing with parties who are represented much in the way that is common at VCAT. Parties will also be able to access alternative dispute resolution processes at the Magistrates Court, and for example, mediation, and this will help ensure parties to avoid the stress and expense of a full hearing at the Magistrates Court. We all know that resolutions by mediation is generally a better outcome for all parties rather than going to a full, stressful hearing. The Victorian Civil and Administrative Tribunal will be able to assist parties with advice with applying to the Magistrates Court. And this bill also seeks to ensure historical cases that were previously decided by VCAT are retrospectively validated. And this will ensure that they can't be challenged after this bill takes effect because of legal technicality. Of course, for our border communities with other states, this legislation is of particular importance. The member for Caulfield raised the issue of backlog of court cases and tribunal hearings. And of course the member for Ivanhoe addressed this, and again I will acknowledge what the member for Ivanhoe said. And the Andrews Labor government's 21-22 budget contained a $210 million package to help our justice system resolve these wait times, as well as providing extra resources for our courts, and expands online services and support staff, including remote hearing services. There also has been a $56.7 million for VCAT to transition more of its hearings online, and this is an example of how necessary it has been to adapt, as all of us have begun to understand that there are different ways of us to do our jobs over the last 15 or 16 months. So it's also important that our courts are modernised to help deal with today's challenges. This bill will also create a new statutory position of Deputy Chief Judge of the County Court and streamline the process for appointing an active Chief Crown Prosecutor. And the new Deputy Chief Judge position will help deliver the work necessary in the County Court by assisting the Chief Judge. These changes are necessary to help deliver equitable and efficient justice in Victoria. I know it will have a major effect on my members and my constituents and assist them greatly. I thank the Minister for the work done to resolve this important issue, and I commend the bill to the House.